Good evening, everyone. Welcome to Football Council. Tonight, we're going to continue to talk about the international transfer of minors regulations, in particular, exception number 2, which pertains to the international transfer of minors within the European Union, the European Economic Area, or within the same country. Please keep in mind, as stated in previous sessions, that any application or interpretation of these exceptions pursuant to Article 19 in regards to the general prohibition of international transfer of minors should be done in a strict and consistent manner in order to better protect the rights of the minors and to prevent any circumvention to the applicable regulations. So also as stated before, we have to understand what is a minor in the context of the RSTP. So to that end, and pursuant to definition 11 of the regulations on the status and transfer of players, a minor is a player who has not yet reached the age of 18. Of course, this definition does not take into account any national applicable law that might fix a different age. So for the purposes of the FIFA regulations, a minor is simply a player who has not yet reached the age of 18. Very straightforward. So let's go now to Article 19 and the general provision and in regards to the protection of minors. Number 1, international transfer of players are only permitted if the player is over the age of 18. In other words, the international transfer of minors as a general rule is prohibited pursuant to the regulations on the status and transfer of players. So the exception number 2 would be B, the player is aged between 16 and 18, and 1, the transfer takes place within the territory of the European Union or EU, or the European Economic Area or EEA, or the transfer takes place between 2 associations within the same country. And we're gonna go through further detail as we go with this session. So as a general scope, while all other exceptions apply globally, this exception refers to a specific geographical area or to specific geographical circumstances. The relevant regulatory framework is only applicable to minor players moving internationally within the territory of the EU or EEA or within the same country. It allows, therefore, players between the ages of 16 and 18 to transfer internationally, subject to certain conditions that have to be met and that we're going to talk about as we progress in this session. So in regards to the original application of the EU-EEA exception, we have to say that it was included in the regulations so as not to contravene the principle of free movement of workers, which is a fundamental tenet of EU law. The exception can be triggered if a player aged between 16 and 18 moves internationally between 2 clubs within the territory of the EU or EEA, irrespective of the player's nationality. This has some caveats that we're going to discuss also. In particular, the minor player does not need to be a national or citizen of an EU or EEA member state. So a simple example would be a minor who is registered at a club in Portugal, which is transferred to a club in France. That, provided that the engaging club meets some conditions that it has to comply with, that exception should be authorized. Very simple, very straightforward also. So has an extended application within the EU and EEA, and in view to comply with the principle of free movement of workers within that region, FIFA has consistently deemed that minor players move to or from a country that has a bilateral agreement with the EU on the free movement of workers equivalent to the Treaty on the Functioning of the European Union, who are moving from or to an EU-EA country should also benefit from the exception. It sounds complicated, but basically this only applies to Switzerland at the present date. So a CAS panel, namely the award that we have identified is 2008-A-1485, found that the relevant rule only applies to workers legally employed in Denmark and did not extend to students. This is very important. On the other hand, the European Court of Justice declared inter alia that if an individual was a citizen of a country with an applicable association agreement with the European Union and was working lawfully within an European Union country, that individual had the same right to work as an EU citizen, and this right could not be restricted. This is pursuant to case identified as C-438-00 from the European Court of Justice. So both rulings, the one we cited from CAS and the one from the European Court of Justice, showed that agreements granting the right to free movement as a worker, applies solely to people who are already working lawfully within a EU country, that is, to people legally employed in the European Union. In other words, the player cannot invoke that agreement to gain access to the European labor market. They can only cite it to assert a right to equal treatment once they are already working legally in the European Union. Very important to understand this distinction. So the burden of proving that any existing agreement between a specific country or a group of countries and the EU includes provisions on the free movement of workers equivalent to those contained in the Treaty on the Functioning of the European Union lies with the player, the club, and/or the member association invoking the exception. And this is only a consequence of a general principle of law that states that anyone invoking a right must prove the facts that grants a person the right that is petitioned. So another CAS panel, namely CAS Award 2012-8-2816, namely FC Girondins de Bordeaux versus FIFA, nevertheless deemed that the European Union nationals should be able to benefit from the exemption regardless of whether the transfer took place within the territory of the EU EEA or not. To justify this conclusion, it recalled that the exception had been included in the regulations to observe the principle of free circulation of workers within the EU EEA. In view of this, the panel found that minor players aged between 16 and 18 who were nationals of an EU or an EEA member state but live outside the European Union or the European Economic Area could invoke the EU EEA exception to justify their international transfer to a member association domiciled in the European Union or the European Economic Area. So let's go over now to the same country exception. So as per the EU EEA exception, several additional criteria must be satisfied for the exception to apply. The nationality of the minor player in this case is irrelevant. The only relevant factor is that the member association at which they wish to be registered is domiciled in the same country as the member association at which they are currently registered. This issue became apparent, of course, after the decision of the United Kingdom to leave the European Union, given that the football associations of England, Scotland, Wales, and North Ireland are all domiciled in the United Kingdom. So let's go over the individual conditions that the engaging club must meet and comply with in order to register an international transfer of a minor. So the first one would be to provide adequate football education and/or training. Therefore, a club must provide the player with an adequate football education and/or training in line with the highest standards applicable in its country. For male players, a club will be in principle will be deemed to satisfy the requirement to provide the best possible facilities only if it belongs to the highest training compensation category for the member association to which is affiliated. In other words, only clubs that are assigned to the respective highest category are generally considered to have adequate football education and/or training in line with the highest national standard. So, for example, a member association that has 4 categories, category 1, 2, 3, and 4, 1 being the highest, 4 being the lowest. In this scenario, the clubs registered classified as category 1 and 2 would be considered in line with the highest national standards. Different case would be, but same principle. If the member association only has 3 categories, then the second category, which would be the highest, would be considered in line with the highest national standards pursuant to player status chamber decisions. So, as training compensation does not apply to female players, the club must provide a statement from the member association to which is affiliated, confirming that the club operates in line with the highest national standards of women's football education in the country concerned. It is important to add also that this principle also applies to male and female futsal players. Furthermore, the amount of time spent training each week is of fundamental importance, as it is exactly how this time is going to be spent. For this reason, clubs are required to submit a detailed weekly training schedule for the player, including the days and the durations of their training sessions. This all has to be submitted to the player status chamber. In contrast to the requirement regarding the player's academic and/or school education, which we're going to see, the player status chamber has not set a minimum number of training hours per week that must be exceeded. Rather, it assesses the relevant information on a case-by-case basis as part of its overall assessment of the obligation, and then decides whether the amount of time spent training will be sufficient and appropriate. So according to a general practice of the player status chamber and also CAS, this assessment is done on a case-by-case basis. So the second condition that any club, any engaging club needs to comply with in order to register the international transfer of a minor and that the exception be authorized is that the club needs to provide academic or vocational education and training. So as it can be understood, not every talented player will go on to have a successful professional career. Any number of obstacles may arise, including injury or the simple loss of interest in pursuing a professional career. However, the professional or football journey of the player comes to an end. Young players must not be faced with the prospect of financial or emotional ruin and should be able to choose a different career path, of course. Having a solid education and or a vocational training will leave them better prepared to face the future away from football whenever this future arrives. For this reason, clubs looking to sign a minor player under the EEA exception or the same country exception must guarantee to provide not just a footballing education, but also an academic and or vocational education. To confirm that they comply with this obligation, a club wishing to register a minor player must, 1, provide documentary evidence that the player will be enrolled in a suitable school or academic institution. 2, confirmation of the qualification the player will receive upon completion of the course. 3, the date on which the player will be expected to graduate from the course. And 4, sign a weekly timetable for the player that indicates when their classes are and how long each of these classes last. Very important to provide this information. Under normal circumstances, the player status chamber will not set any minimum requirements as to the level of qualification that a minor player must achieve, but the club must demonstrate that the player will receive a specific and recognized educational qualification that will enable them to pursue another career outside of football in the future. Generally, the player status chamber expects a player to be in classes for a minimum of 8 hours per week. So the third condition the clubs wishing to register an international transfer of minors need to comply with in order to have this exception authorized would be to provide care, supervision, and accommodation to the minor. A young player who leaves their family and moves to a new country to play football will face numerous challenges, including, among others, dealing with an unfamiliar environment, the absence of their family, friends, and other people they trust. And also they need to adapt to a new culture and potentially also a new language. Therefore, having a solid structure in place in their new life will help them to adapt to their new circumstances. Given the situation in which young players find themselves, it is of the utmost importance that they should have someone to take care of them and make sure that they are looked after in an adequate manner. Remember, we are talking about minors. So the best possible living conditions must be ensured regardless of whether the minor lives with a host family or in a club accommodation, and they must have access to a reliable, long-term point of contact at all times, such as a mentor appointed by the club. Any club intending to register a minor under this exception is obliged to make all the necessary arrangements in this respect. So in order to satisfy the player status chamber that it has complied with its relevant duties, it must present documentary evidence that it will provide the player with accommodation that can be, again, with a trusted host family or at the club campus, and indicate the name of the person responsible for the player, or namely the mentor, right? So lastly, the fourth requirement is to present proof of compliance with obligations to the member association. That's no longer to the player status chamber, but to the member association of the relevant club. From a formal point of view, once the international transfer of the minor player or the first registration of the foreign minor player is approved by the player status chamber and the member association proceeds to register the player with its affiliated club, the club must provide the member association with proof that is compliant with this obligation. This procedural element ensures that the respective conditions are complied with in practice and not merely on paper. So that's basically the exception number 2 and his particularities and details. And now we're going to talk about, again, the scenario of a first registration of a foreign player, pursuant to Article 19, number 3 of the regulations on the status and transfer of players. Namely, states, the provisions of this article shall also apply to any player who has never previously been registered with a club, is not a national of the country where the association at which he wishes to be registered for the first time is domiciled, and has not lived continuously for at least the last 5 years in said country. Any minor that is in these circumstances, all the principles regarding the international transfer of minors will apply to the first registration of this foreign player, minor. So in summary, our main conclusions are, as a general rule, the international transfer of minors is prohibited pursuant to the regulations on the status and transfer of players. 2, while all other exceptions apply globally, the second exception in the regulations refers to a specific geographical area or to specific geographical circumstances. 3, this exception was introduced in order to comply with EU law in regards to the free movement of workers. 4, EU nationals that do not live inside the territory of the EU EEA shall have the same labor rights, especially in regards to the free movement of workers within the European Union, as well as any other EU national living within the EU or EEA. And lastly, the principles applicable to the international transfer of minors apply also in cases of first registration of a minor pursuant to Article 19, number 3 of the RSTP. So guys, that would be our session for tonight. Join us next Wednesday, where we're going to go into the other exceptions to the general provision on the international transfer of minors. So until then, let me thank you once again for joining us. And please, until then, be safe. Take care, guys.